and I will have the pleasure to chair the morning session devoted to the effects of differentiated integration. We have two papers scheduled for this session. The first one by Ioannis Vergioglou from the ETH in Zurich is entitled The Effects of Differentiated Integration on EU Institutional Trust. And then the second one entitled Differentiated Integration, Actually the Danish Case in Justice and Home Affairs, was written and will be presented by Marta Migliorati from Hertie. Each presenter will get approximately 15 minutes for the presentation. Then I will offer a few comments, and then we'll open a Q&A session.
Share my screen, just one moment. Okay. Can you all see it? Okay, perfect. So it's a great honor to present this project as the first one today. It has slightly from EU institutional attitude, because that is, in my opinion, the end of the project is to launch the institution general support. So I will start with a brief mention of the data collection, the proposed theoretical framework, the methodological framework, and then go through some initial results, as well as, in the end, talk about the next steps of the project. So the data that I have prepared for this preliminary part of the project is just a time series between 2004 and 2017. It is taken from Eurobarometer and Eurostat. Nothing really special, just the main outcomes that I will be looking at is Parliament, Commission, Central Bank, and National Parliament Trust, and then a number of economic and demographic, let's say, variables for synthesizing the units, as we will see in a bit. As you read from the paper, the main typology and the main thing that I expect is a very simple interaction between expectations and outcomes of differentiation and integration. So in this, 2x2, very classic typology, we can see that we expect positive effects when countries get what they want from the process of differentiation or integration, and negative effects when we get a different result than the one that is expected or desired. The methodological framework is, in my opinion, the main that I make in this paper, because it has never been used in the context of differentiated integration to see the effects of it. It is a very appropriate framework for the specific question, because it provides an intuitive method that is similar to, at least in intuition, of comparative case studies. It allows inference within the context of causal inference, and it provides a way of estimating effects which is not related to the post-intervention outcomes. So it gets rid of a lot of bias this way. So I'll go straight on to the results, because that's the main thing that I would like to discuss. As you read from the paper, I applied this method onto one case of each one of the proposed outcomes from the typology. There was no specific way that I picked the cases. It's just that there was usually just one case for each one of them, because my time period is so short at this stage. But nonetheless, I found interesting results for all of them. So here, in this first one, we can see that this is the effect on member states that got a differentiation on the fiscal and economic coordination provisions. As you all know, the fiscal compact, as it came to be known, was adopted by all Euro countries, as well as some countries that were not in the euro voluntarily, but it was of course not adopted by a number of countries that chose not to opt in, let's say. So here we can see that not being bound by the fiscal or economic provisions of the treaty has a positive effect on European Parliament trust. The effect, as we can see here in this lower table, appears to be, at least for the 5-year period after the treatment that we have in the data, appears to still have a significant effect, and quite a large one. The effects on the European Commission are quite similar, and there doesn't seem, I don't present all of the outcomes that I investigated, but there doesn't seem to be anything interesting for the European Central Bank. If anything, it follows a similar trajectory. And for the national governments, there's not much. Moving on to the next stage, this one uses the conventional synthetic control method for an interesting case that is maybe not strictly speaking a case of differentiated integration, but it is a case of, let's say, informal or at least expected differentiation in the future. So as you read in my draft, there was a promise on behalf of the Council that the Czech Republic would be included in the protocol for the Charter of Human Rights when the accession of Croatia would happen. The government that was elected in 2014 took the initiative of basically revoking this request, this request from the European institutions, and the outcome we see is a very significant negative outcome. So here in this table, you can see that the treated and the synthetic units for Croatia and synthetic Croatia, as we can see also for the special path dependency predictors, they're quite similar, if not identical. As you can see from the path plot and the gap plot, the effect between the synthetic unit and the control unit becomes very significant after this government is elected, which takes away these two. Oh, I should also mention that this is the year also that the Czech Republic started implementing parts of the fiscal compact, which the government previously had not signed. So again, very large negative effects, as we expect from the framework. And these are probably the ones that are most robust in the traditional sense of the literature, because as you can see here, I implemented a number of placebo tests, both in time. So here we exchange the treatment instead of 2014, which is the year that we see these two, let's say, differentiation events. We have 2009, where other things happen, and yet there is no effect between the synthetic and the control unit under the same specifications. And perhaps even more importantly, during the year that we have these two events in Croatia, we conduct a placebo in space, which basically means that we run the same method under the same, basically assigning the treatment to all the cases that we have in the data set. And as you can see very well from the plot, the Czech Republic post-pre-root mean square prediction error is well distinct in the distribution, meaning that in conventional terms, this would result in a p-value that is well below the threshold for what we call statistical significance. Moving on to the positive cases, we see an interesting case for Bulgaria and Romania. As you know, the countries were supposed to enter the Schengen area. In fact, they fulfilled all of the formal conditions and they were approved by the parliament. However, their accession was blocked by the council approximately a year after or actually less than a year after they were approved by the parliament. So this is depicted in the in these plots to an extent, but is a much more mixed finding compared to the rest. So initially, for the European Parliament Trust, we see a very statistically significant initial effect, which then phases out and becomes and doesn't seem to be significant after a few years. And the same goes for the Commission, although the problem is that we don't have a significant effect in conventional terms in the very beginning. It's more of very short-lived, if anything. As you can see from this lower last plot that is not included in my draft because I just made it this morning, this is the effect for the Commission in the year that the countries were rejected from Schengen. The problem with implementing this particular method for this case, and why I'm saying that it's maybe a mixed finding and there needs to be more work, definitely, specifically on this one, is that there is sort of a double treatment. So on the one hand, you get the approval by the Parliament, and then on the other hand, you get the disapproval by the Council. Another unfortunate fact is that I don't have data for the Council at this time. So this would need to be investigated further in the future, this case. The last case is the effects for Latvia and Lithuania joining the eurozone. This is based on the Topology case where countries desired and expected differentiation and indeed got it in time and as it was planned, more or less. Very evident, very large positive effect on European Parliament Trust, on Council and the rest. It follows very similar things. That's why I don't show them. This is potentially another case of double treatment, but since the generalized synthetic control method allows for it, I have also estimated the individual effects for Latvia and Lithuania. And as you can see, I mean, they follow somewhat different paths, but they still are significant on their own. So the overall takeaway from these very basic typology that I propose and these cases that I implement is that there are some very encouraging exploratory findings. I would say that given the method and the data that we have, these are certainly cases where there is something going on institutional trust or trust towards the EU or however you want to call it. The methodological framework seems to be generally appropriate. It seems to work well. As you saw, the synthesized units were very accurate. But this should be kept in mind, as I repeat again and again in the framework, that these are exploratory results, these are preliminary findings, and the next step should be to create better data, more data, and really have a much more rigorous way of creating the specification and the case selection. So one of the main issues with this method is that you really need to make sure that there's no idiosyncratic cases in the control group for that you synthesized from. So the donor pool, as I call it, from which these potential outcomes are constructed, needs to include cases that don't have something crazy going on in them. This is partly why I don't include the UK in these donor pools, but potentially there are things to be said about some of the countries that I include. For example, even though I should say that from my initial exploration of the data, there doesn't seem to be such a problem, but definitely looking at the cases individually would add value to this project. And perhaps other parts of the overall differentiation project would also benefit in terms of looking at the cases the country reports presented yesterday about public's and parliament's perceptions of differentiation. We actually prerequisite for my framework to be valid. And with that, I am finished. I would like to give a lot more room for questions and sessions. This is an early stage.
Thank you, Ioannis. Perfect timing. So we move now to the paper by Marta. Marta, the floor is yours, please.
Hello. I'm sorry, just 1 second that I share my screen with you. Wait a second. Okay, can you see it? Yes? Great.
Yes.
So welcome and thanks for listening in advance. So we are shifting to a completely different focus here. Actually, I mean, we are still in the realm of, so to say, the causes of differentiated integration, but I'm tackling it through the analysis of our case study, so the Danish case in justice and home affairs. So this is like, so to say, a little piece of a bigger aim we are pursuing through the work package 5, which is assessing the actual differentiation stemming from treaty level differentiation in the area of core state powers. And well, the general puzzle that we have is that we do know about the causes of differentiated integration, but we know less as of the consequences of differentiation in treaty law. And therefore, more specifically, we want to know whether adopted policies by opting out states match legislative differentiation, and whether it's the case that there is deviation in the policies adopted. So we do have some hints about the fact that there exists a mismatch between law and practice. And there are some sources which I'm listing here in this slide. We know that there are some hidden exemptions to the exemptions. So for example, we have Denmark applying Schengen rules, although both primary and secondary law doesn't say so, and we will talk about it in a bit. That we know that bureaucrats in Brussels may behave differently than the opt-outs in place in their own countries, and we have some case studies by Adel Nissen on UK and Denmark officials in Brussels. And also, we know that adopted policies may be overall different from what the opt-outs say. So we have an example of UK and Ireland contributing for years to the EU border agency Frontex, although they're legally not bound to the Frontex regulation and they opted out from it. So how do we account for this potential mismatch? We know that on the one hand, we have opt-outs which are stemming from a situation of constraining dissensus and sovereignty concerns. And on the other hand, however, these opt-outs may be counterbalanced, so to say, by an inconsistent behavior enacted by elites and politicians moved by pragmatic reasons that will lead to a situation of policy convergence. So what I call the situation in the paper is a situation of uneven rules and even practices, paraphrasing Vergioglou, who talks about even rules and uneven practices. So the question here is how will we account for this mismatch? Normally, in a context of non-differentiation, we would imagine states signing treaties and not opting out, and then being not very good at implementing these laws. In this case, we are kind of a reverse situation. And I hypothesize a set of mechanisms that would produce such decoupling between norms and policies adopted. So we have an initial situation in which we have national elites that seek to deepen integration by signing a treaty, for example. And we have a public which has sovereignty concerns, which is perhaps Eurosceptic. And as a response, we have politicians or the government in place negotiating exemptions for its own country, and eventually the outcome, we know, is legal differentiation, so a situation of uneven rules in the treaties for these opting out countries. Over time, however, we also know that we have processes through which integration deepens through new treaties, and interdependence within policy areas and between member states increases as well. And so how do elites respond to such increase of such deepening of integration and increasing interdependence with opt-outs in place, where they could have ad hoc arrangements, they could seek cooperation through transgovernmental channels, which are something very common in the post-Maastricht era, for example, EU agencies, and also through mimicking practices, so by adopting rules which are very similar to EU rules. The outcome in this, at the policy level, would be towards policy convergence, so towards even practices. And the mismatch between these practices and the legal differentiation is called, in this paper at least, decoupling. But let's see whether these mechanisms find any corroboration at all from this case of Denmark. Brace yourself, because it's a long case, and if you read the paper, I know it's pretty intense, and I'll try to be very concise in explaining it. So the method is an in-depth case study analysis as a narrative enables to detect the steps in the causal chain that has been identified. Sorry, I forgot about this slide, but let's start with the Danish story. So it all starts with these Edinburgh agreements negotiated by the Danish government in response to the fact that the Danes rejected the adoption of the ratification of the Maastricht Treaty in 1992. And the Danish government at the time had to face a pretty split public opinion during Maastricht, and observed a pretty large consent on exemptions when they proposed them as an alternative to the Maastricht Treaty as it was. So lots of secondary sources confirm that, that there was a pretty big work on the elite side to persuade the Danes that the Edinburgh exemptions were guaranteeing Danish sovereignty, and that they really wanted to go on with the integration with these opt-outs. And indeed, the referendum result was positive, and the outcome were legal level opt-outs in several domains, including justice and home affairs, which is the area we're analyzing in this case. And then at the practical level, this opt-out in justice and home affairs related only to community methods, so qualified majority decision-making. And at the time, there was no such a thing in justice and home affairs. So at the policy level, the consequences were not so relevant, and there was no decoupling, so to say. But the story changes, indeed, with the Amsterdam Treaty and beyond it. The Danes, the Danish governments and political parties were quite aware of the problems of signing the Amsterdam Treaty. They were kind of afraid that a referendum would go wrong, like it happened in Maastricht. In fact, polls since 1993 had regularly shown a majority of citizens upholding the exemptions obtained in Edinburgh. And therefore, they really adopted a pretty defensive strategy towards Edinburgh exemptions. They said the exemptions stay, don't worry, but we really want to sign the Amsterdam Treaty. We really want to be in, because we got so much out of it, and it's gonna be great for Denmark. And they made it, and the referendum was positive once again. Well, it's not working. Sorry. There is something wrong with my slides. Okay. So the legal level, what happened was just that the opt-outs that they had before just remained in place. But at the practical level, this wasn't really the case, because Amsterdam, as we know, was very important and signed a very important change in the EU architecture, because justice and home affairs was moved from third to the first pillar, which meant for Denmark a pretty big problem, because Denmark was entering the Schengen area in the year 2000, and they wouldn't be able to participate in the Schengen acquis if this opt-out was in place. So what they did at the policy level was negotiating this Schengen technicality, which is the way it's called in Brussels, where basically it said that Denmark is free to choose whether or not to follow Schengen rules. The truth is that Denmark has been adopting and applying all legislation building on the Schengen acquis to date, and this is confirmed by an attaché I talked to in Brussels. Besides this, from Amsterdam onward, we also observe a pretty important increase in cooperation in justice and home affairs through Europol, by building the European arrest warrant, by creating the Eurodac database. And Denmark was pretty involved in all this, very compliant with the European arrest warrant, very active in its Frontex membership, and so on and so forth. So we do have here with Amsterdam a situation of decoupling which starts existing and intensifying over time. And this becomes even more evident with Lisbon and with the post-Lisbon scenario, because in the case of Lisbon, it was a bit different, because the Lisbon Treaty did not require a referendum, because the court decided that there was no breach in national sovereignty in this case, and the Danes are called to the polls with a referendum only if a treaty is going to breach national sovereignty. I don't know what is the benchmark, to be honest. I should look into that. So the parliament ratified the treaty, and in the treaty, Denmark pledged to work towards a progressive elimination of the opt-outs in place. And in order to abide to this commitment, the government launched a referendum in 2015, and this time they were pretty confident that they would make it. The polls seemed favorable, but it was also 2015, and there was a refugee crisis going on, and this might have affected the Danish vote. But in any case, the referendum was this time negative, and the legal outcome of this was a full opt-out from justice and home affairs cooperation for Denmark. Why was this a full opt-out? Because with Lisbon, we have the end of the pillar structure, and justice and home affairs falls entirely under the community method, including police cooperation and justice cooperation through Europol and Eurojust. So the problem here is that Denmark did not have the right to be part of Europol and Eurojust anymore, and that was pretty bad. And the response of the government was, at the policy level, was to negotiate parallel agreements to circumvent the opt-out, a backdoor entrance to the Eurojust and Europol management, as the media depicted it. And also they obtained quite favorable, a very favorable arrangement that may leave the situation very similar to what it used to be before Denmark got out of these agencies. So this is the story. Sorry, decoupling again. Yeah, this is the story. And as to Denmark, what do we see? On the one hand, we see rigid formal opt-outs, which stem from Danish citizens' wish to maintain national sovereignty intact. There is evidence of a very great awareness of politicians of the public sentiment, and therefore the tendency to keep these opt-outs in place, but also a systematic pursuit of convergence in this policy area, way beyond formal treaty rules. More in general, what does this tell us? Well, on the one hand, it tells us that elites can construct legal and pragmatic ways out of clear political dilemmas. And this is a quote from Hertie that I really like, because I think it kind of describes a bit what's going on here. And the consequence is that differentiation actually may end up being less than what appears from this from such opt-outs at the treaty level. What are the consequences of this? Well, I believe that this case tells us that accommodating differentiation demands risk ending up accommodating Euroscepticism somehow, and that and this practice may just end up delegitimizing the EU as a political entity, because yes, okay, let's opt out, but you still exploit it as a policy supplier if that's convenient. And finally, well, this opens, of course, a debate on whether there is democratic legitimacy and accountability in such decoupling practices, because on the one hand, we say we have negotiated this and we got it, and on the other hand, there is a pursuit of much more pragmatic ways towards convergence with EU rules. And that's all on my side. Thank you for listening. I hope I was within the time. Thank you.
Perfectly on time. Thank you very much. Okay, so I will now offer just 2 comments to each presenter so that we have plenty of time for Q&A session. So let me start with Ioannis. So first of all, your intention to investigate the effects of the on public opinion is of course justified, no doubt about this. And I like in the paper that you acknowledge some limitations of your approach. However, you seem to be focused mostly on the data issues. And I would like to encourage you to go back a little bit and think more thoroughly about your theoretical approach, okay? To explain your main considerations. Why this is important? Well, I believe that you could start with a general overview of the determinants of public opinion formation in the EU. Because the first question from a theoretical point of view that I asked myself was about whether you expect something special, something distinctive about the DI as public opinion formation is concerned, or you would rather say that DI and the processes related to public opinion formation belongs to the overall category, similar to many other situations that we know from the EU politics, when some member states are portrayed as losers and some as winners, okay? So when I was thinking about what you framed as these empirical expectations, I started to wonder, for example, whether it would matter to you, to your expected outcome, that was decreased or increased level of support or trust in the EU, whether instead of, for example, saying DI, you would simply say losers or winners, those who are portrayed as losers or winners, okay? So for example, you would say the expected outcome of member state achieving success is an increased support for the EU. So in other words, my suggestion would be to think more broadly, to extend your theoretical perspective to include a larger body of literature on public opinion formation within the European Union. And the second comment is short, and it concerns the problem of salience. So obviously some areas that you study are more salient than others, and my question would be, how does it matter for your research? And then moving on to Marta's paper, well, definitely dealing with an interesting case. And I agree that this also is interesting from the point of view of legitimacy, representation, and accountability. And then your approach, I think, is also valuable to look into the real, so to say, that you say actual policy making, to go beyond the formal treaty level differentiation. But I also understand that the paper is like a starting point for extension of your analysis to some additional cases. But even if you stay on the example of Denmark, well, I would be happy to know how politicians justify decisions, okay, for such a decoupling, as you say. Is it a matter of public concern? I mean, how the press report on this? So these are interesting, and of course, ultimately, how the public opinion perceive it. Because if that's really a problem, okay, from the point of view of the legitimacy, when, you know, politicians really try to go against the officially declared opinion in the public referendum. And yet we know very well that Denmark is portrayed as one of the countries with the highest level of democracy, quality of democracy, where citizens are, you know, among those who have the highest level of satisfaction with how democracy works. So perhaps this is not salient in the end. You know, they are happy that they have offered their view during referendum, and the rest is not that important. So that is the things I would be happy to know more about. And the second comment is about your focus on what you say, what you framed as national elites. And if I understood correctly, that mostly mean government and the main political parties, at least those pro-European. And I wonder whether you would consider extending a little bit your focus and also include some other actors. From the EU side, I'm thinking about the European Parliament, which, well, for a number of years also has an important leeway and important role as far as justice and home affairs is concerned. But also I'm thinking about some national actors, including courts and national administration, which is in the end responsible for implementing this decision at the national level. And Patrycja Dąbrowska-Kłosińska, who is here, and perhaps who will comment on this later, just brought to my attention an interesting case law of the Danish Supreme Court on a number of cases, including an interesting ruling concerning the Danish immigration policy, and other cases where the Danish Supreme Court in effect undermined some basic principles of EU law. So here I have read a report about the ruling in the IOS case of 2016, which some commentators actually described as, I quote, a turn towards a greater national patrolling of the limited mandate given to the EU. So there are some interesting analysis of the role of the Danish Supreme Court in the Verfassungsblog, and I think you could make use of this.